having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Killing me, Jeannie. It's hot
It's
here.
warm in here.
God almighty.
You may be seated. Our first case today is DeVilliers versus Texas. Deals with eminent domain.
Good morning. Thank you for meeting in this courtroom today to redress and hopefully serve justice to not only my client, Mr. DeVilliers, but also to those who have been violated with the Fifth Amendment rights as they have been stripped away within the state of Texas. To outline the past occurring events, Mr. DeVilliers' family has recently endured the betrayal of the state of Texas as they left him and his family bare to fend for themselves after building an infrastructure that blocked the natural flow of water and flooded his property. I stand here today on behalf of my client to sue the state of Texas under the taking clause. Under the taking clause, it states that nor shall private property be taken for public use without just compensation. The state might argue that nothing was exactly taken from Mr. DeVilliers because none of his land was physically taken, but it indeed was. After the flood, his property was imperiled. As the Fifth Amendment states, to protect against the taking of property by the government, including destruction, it is only right for the state of Texas to abide by the U.S. Constitution. The Constitution at which must apply to all states, regardless of whether the Congress has specifically passed law commanding compliance. I end my statement with saying it is the highest law in the land, and for the state of Texas, violating the Fifth Amendment is equivalent to dishonoring the principles and values that America stands for. Thank you. And I would now like to pass it over to my partner, Attorney Knotts, to discuss fair compensation.
Once again, good morning, Your Honors. I stand before you not only as an advocate for justice, but in support for the due compensation rightfully owed to Mr. DeVilliers. It's time to talk about the fallout of this case, which has turned into a poor example of justice, especially the compensation owed to the victim. Mr. DeVilliers carried a conviction with him, a way that has not only affected his personal freedom, but also permanently changed the course of his life. The damage of his livelihood, emotional health, and reputation is incalculable. It is clear from looking at the flaws in the legal system that resulted in this tragic circumstance, the damages must be compensated for in order for there to be a fair conclusion. I ask the court to acknowledge the mistakes that occurred in Mr. DeVilliers' case and the significant effect that they had on his life. Payment is an acknowledgement of the cost Mr. DeVilliers suffered as a result of the system's failure to uphold his rights. It is not merely a token of a gesture. Your Honors, at this time, my partner, Attorney Wynn, will pass out evidence referring to the proceedings of this case. In Chapter 252 of the Texas Agriculture Code, Section 1, Title 8, it states that it is a criminal offense if or when a person steals, destroys, or otherwise causes the loss of an animal or crop without the consent of the owner or operator. Also damages to any property on or from an animal or crop facility. Due to the floods on his land, Mr. DeVilliers lost a significant amount of crops. The plants were simply abolished, by which the floods washed them all away. During this time, he lost a substantial amount of animals in addition to his crops, and he suffered an important financial setback. Texas's laws protecting livestock owners, as found in the Texas Livestock Code. There are clauses in this code that demand compensation for livestock damages brought on by the use of eminent domain. In addition to any additional losses or costs suffered as a result of the damage, livestock owners are entitled to be reimbursed for the worth of their animals. Furthermore, overall rights of citizens in the Fifth Amendment within its guarantee against self-incrimination and importance of a fair legal system is entitled to the rights of all citizens. The Constitution is not an abstract concept, but a living assurance of justice for every citizen. This should be the bare minimum that Mr. DeVilliers receives. To uphold the Constitution, I finish, with no state should be more superior than its citizen. Thank you.
Okay, and now we will hear from Mr. DeVilliers' son. I'm sorry, the state of Texas.
Good morning, Your Honors, and thank you for meeting me here today to listen to my case. Interstate 10 was originally built in 1957 as a two-lane road. However, in the early 2000s, Texas widened over 10 miles of I-10. Within these 10 miles, Mr. DeVilliers' land sat on the north side of the state road. When building onto I-10, Texas never once built onto Mr. DeVilliers' land, making this case no longer an eminent domain case, but just a way for a generational farmer to make a quick buck by suing the state. The extension of the interstate from a two-lane road each way to a three-lane road was crucial to the economy, because truckers and businesses travel this interstate daily, and if this change was not made, the road would have continuously flooded, being an inconvenience to businesses and millions of everyday travel. This would hinder the safety of everyday lives. While DeVilliers' land and cattle is important, and they do matter, can you imagine how many innocent lives would have been lost if the road would have flooded while they were driving? People were coming home from work and coming home to their families, going to their parents, their kids, their grandkids, going to anybody that they could. And buying cattle is just an easy process. It may be expensive, but you can always buy new cattle. You can never replace the family members that you could have lost if they were on the road that day, and it was still a two-lane, and they were trying to drive home. And the floods were not caused simply because the state of Texas built the interstate in an unjust way. The floods were brought on by Hurricane Harvey and Hurricane Irma, two of the most destructive hurricanes to hit Texas. Hurricane Harvey hit in 2017 and caused $125 billion worth of damage and 68 deaths in the state of Texas alone. Over 300,000 structures were flooded. DeVilliers should have been happy that he was not part of the 68 people that lost their lives that day and not suing because a natural disaster hit his farm. DeVilliers versus Texas is crucial to understand the Fifth Amendment and the taking clause, because if the court rules in DeVilliers' favor, then this will open up plenty of doors to many more cases being accepted in the future for the wrong reason. The constitutional question that is at stake today is if Mr. DeVilliers should be able to sue the state of Texas directly under the taking clause of the Fifth Amendment. A case that is similar to DeVilliers versus Texas is Kelo versus City of New London. Now, while they were both very different and took place in very different places, they were both citizens fighting for their property. However, the city bulldozed over Kelo's house and her entire neighborhood. DeVilliers just wanted compensation for his lost crops and animals, even though it was not the state's fault that this happened to him. It was an inevitable natural disaster that hit the entire southern border of Texas. And the Fifth Amendment clearly states that it will include protection against the taking of property by government without compensation. Not once was their property taken from him. So this is no longer a Fifth Amendment case. It should not be treated as a Fifth Amendment case if there was never property that was taken in the first place. And in a small town in Franklin, Texas, is my aunt, Annie Louise, lives there. And when Hurricane Harvey hit, her house was flooded, and she was not given compensation for her flooded house either. And this was 2 hours and 30 minutes away. There's no way I-10 could have possibly made her house flood just as bad as DeVilliers. Thank you.
Do you have any questions in this case? Okay.
Did he get paid for the property? That'd be you. Did he get paid for the property?
He had no compensation.
So no compensation, did they build it, did they not build it on his property?
They did not build it on his property,
Are
but
they saying that where they built it at caused his property to flood?
Yes, sir.
Did it flood before they expanded?
No, sir.
So it never flooded before?
No, sir.
Explain about what you explained to me yesterday about the drainage.
So basically, the natural flow of the water after a rain would cross this barrier that they built up and head down to the Gulf of Mexico. But since this infrastructure blocked, yes. So basically, it was like a pool. Like in a pool, there are walls up, and so the water can hold it. And that's exactly what happened to his property.
Your Honor, I'd like to speak on this subject. I got in touch with an engineer, and he told me that all roads are slanted 2% and have a drainage so that water does not build up on the interstate while people are trying to drive, causing them to hydroplane and go off the
Where does
road
the water
or
go?
roke into other people. Sir?
Where does the water go?
In the
It goes somewhere.
drains.
I know, but if it backs up, where does it go?
Yes, this was a more than 3 feet wall that just blocked.
Pictures here, is this after a hurricane? Or is this after normal rain?
I believe that is after just normal rain, heavy rain,
That's
just
what
normal
I'm-
heavy rain.
If it, catastrophic events, if it's hurricanes, it's gonna flood, things are gonna flood. People are gonna lose their lives, and animals will lose their lives. But if that's after a normal rain, it would be different to me to know whether it was after a hurricane or normal rain.
Your Honor, it was after 2 hurricanes.
Two hurricanes.
Harvey and Irma.
So,
But after the hurricanes, nothing. It still, the water went nowhere. And they won't let them build a
did the
river.
water stand? It
Sorry?
never drains, it just stands?
Stinks.
You ever see when you go to Dothan, they're right outside of Midland City, where it rain, and then it's like a big pond out there if you have a lot of rain, and the whole field, like half the field's covered with rain, which there's no crops to grow in that. And I'm sure they lose a lot of things that way too. So is that what we're talking about?
Yes, sir.
Something like that with no drainage system, nothing?
Yes, sir.
The interstate had a drainage system. It was draining to a gulf.
That's what I'm asking.
The
You said a while
farmland.
ago, beforehand, it would drain to the Gulf. Is it still drain to the Gulf?
It's no longer draining to the Gulf because of this infrastructure that was built and now blocked.
Mr.
But
de
it was
Villiers,
originally going down to the Gulf.
Mr. de Villiers' land did not have any drainage systems to protect him from these hurricanes. The interstate, the state of Texas, tried to place some precautions and compromise with them and put in drainage systems to keep this from happening, but we could not help that a natural disaster hit the farm twice and caused them to flood and caused their animals to die.
How long has the interstate been there? Since it was expanded, it's like 10 years, you said?
Yes, sir. It was in the
Expanded
early
10 I'm sorry,
2000s.
10 miles. When
Yes.
was it?
In the
20
early
years?
2000s.
Early 2000?
Yes, sir. But it was originally built in 1957.
How long has he had the property?
Generation.
This was passed down from his father of fathers.
Did he have proof that it never flooded before the interstate?
He says it.
That's what that's where it lies. I mean, I
Whose,
understand the
whose
problem.
case is this on the court?
Your
Okay,
Honor, I'd like to
I
see-
think before y'all deliberate, some of those questions she needs to look up. Yeah,
That's where it lies.
we jot some of that down? Okay, yeah.
I would like to see this proof that it was never
I would
flooded
too,
beforehand.
because, I mean, that's where it lies.
I think she can find that. All right, are we ready? Our next case is Garland v. Cargill.
Good, let's dig it. Good morning, Your Honor. Thank you for hearing our case today. It's a pleasure to be here this morning. I'm going to start off with a question first. Say you're out in your yard and your neighbor walks up to you and says, "Hey, I don't like your mailbox right there. I don't think it looks pretty. I think you need to move it 3 feet to the left or 3 feet to the right. Would that be fair if he said it was illegal? Would it be fair for him to say, hey, I'm going to sue you now because your mailbox doesn't look right, just because of his opinion? Well, the Alcohol, Tobacco, and Firearm Administration did just that. They simply made up their own opinion about my client, Michael Cargill, over a bump stock, which was bought legally. They seized it, they made him surrender, and tried to convict him as a felon overnight because of their ruling. Mr. Cargill said it perfectly on the phone with me Thursday night. He told me that Congress makes federal gun laws, ATF enforces them. Government agencies like OSHA and ATF enforce the laws made by elected officials. So how are unelected officials going to make you a felon overnight just because of their opinion? The ATF for many years recognized that bump stocks were not illegal. Its sudden reversal can only be explained as a decision to allow expediency to the Trump rule of law. Not only did they do that, but they seized Mr. Cargill's bump stocks by making him surrender them, which were bought legally. They bought them legally before they ruled it illegal in 2018. The bump stock is just an attachment on the gun. It just improves efficiency. So if the ATF makes it illegal, then what stops them from banning scopes, hair triggers, clips, lower receivers? They all make guns shoot more efficiently. So there's no reason to ban something that is just an attachment. The ATF has also ruled to ban pistol braces. In 120 days, millions of Americans will become felons overnight, just like Michael Cargill. The shady ATF also exclusively operates by private letters. It has not published a public ruling since 2017. Their ruling and rulemaking should be open and transparent according to the Administrative Procedure Act of 1946. I will now pass it over to Attorney Paul.
Good morning, Your Honor. I'd like to present this piece of evidence to the court. So what you're looking at here is a bump stock and a machine gun. In the last few weeks, as I've worked on this case, I've tried to find a machine gun with a bump stock. And as you know, there isn't one. Why? Because adding an attachment to a gun doesn't change the mechanics of the gun. The only thing a bump stock does is it frees the weapon to slide back and forth rapidly, harnessing the energy from the kickback shooter's field when the weapon fires. The person shooting the gun still has to pull the trigger, which makes it not automatic. So you still have to pull the trigger. So for the definition by the ATF, the term machine gun means any weapon that shoots is designed to shoot or can be readily restored to shoot automatically more than one shot without manually reloading by a single function of the trigger. The frame or receiver of any such weapon, if both the feeding and ignition procedures are automatically cycled, the weapon will be considered fully automatic and will fire continuously as long as the trigger is kept depressed and ammunition is feeding remains available. You see, pulling the trigger or pull a hold of the trigger makes it automatic. Bumping the trigger does not. In closing, how do you classify a machine gun? It shoots automatically more than one shot without manually reloading. In Mr. Cargill's case, his gun is not an automatic. Without the bump stock, it is. But with it, it is not. Ask yourself how that makes sense. That adding one attachment does not change the mechanics of the gun, turns the gun into a machine gun. Mr. Cargill has been unlawfully convicted and turned into an overnight criminal. What does it say about our judicial system? Thank you, Your Honor.
Good morning, Nars. Thank you for hearing my case. So, to start off with, the Second Amendment gives people the rights to carry guns for legal purposes and under the definition of a legal weapon. In 2017, Las Vegas shooting is considered the deadliest mass shooting by a single gunman in American history. Within 10 minutes, 12 bursts of gunfire killed 58 people and injured around 400 people. So a regular AR-15 with no bump stock shoots around 45 rounds a minute. An AR-15 with a bump stock fires between 400 and 800 rounds per minute. An automatic weapon fires between 500 to 1,000 rounds per minute. An AR-15 with a bump stock is significantly closer to an automatic gun than a regular AR-15. The final rule on the machine gun in the Gun Control Act and National Firearms Act includes bump stock devices. Devices that allow a semi-automatic firearm to shoot more than one shot with a single pull of the trigger. By harnessing the recoil energy of the firearm to which is affixed so that the trigger resets and continues firing without additional physical manipulation of the trigger by the shooter. So the shooter does not physically have to pull the trigger. As soon as it hits his shoulder, it's hitting his finger, and more shots are coming out with each pull of the trigger, like not just one bullet's coming out. The ATF does not have authority to change this gun law, but the Department of Justice is the agency for enforcing federal laws of the United States, and following the Las Vegas massacre, the Department of Justice amended the regulations of the ATF to change the definition of machine gun to include the bump stocks. The ATF did not immediately change this rule. It took 2 years after the shooting for bump stocks to be made illegal, so it took a lot of time to decide this law. The federal law strictly prohibits any weapon under the definition of machine gun, but allows a person with a special permit to possess one. In closing, if this has not persuaded you to plead my case, I have some evidence to show you. This is a video of an AR-15. An AR-15 with a bump stock. Of course, he can shoot a little faster than me.
So what on me?
No, it's on now. That sounds a lot more like a machine gun than it does a semi-automatic weapon. And for people who are immature and dangerous to America, not just regular citizens who may think that they should have one, it's a lot more dangerous for someone who is willing to harm someone with an automatic weapon. Thank you.
Somebody else want to talk? 'Cause
Guys? You're supposed to have some questions. We got any questions?
I got my own, but whoever wants to do it first.
They're supposed to have some. Okay.
Was Mr. Cargill aware of the banning, or was he just like unaware of it?
When I called him on the phone, it sounded like it was immediate, and he said, word for word, he was free one day and then he was made a felon overnight.
Piggyback on that, you said that it free one day and made overnight. Is this law?
Yeah, this is law
Is
now.
bump stock law? Did he not know the law?
When he bought it, it was not a law. Or
When he bought it was legal.
yeah, it's legal.
Okay. All right, but I heard you say amendment.
Yeah,
Did they amend?
they
the
amended
law?
it to a law. So now, it took 2 years after the Las Vegas shooting. So he's had the bump stock for about a year. So he kind of knew over time.
But in the amendment, did it say in the amendment that bump stocks that were bought before the law was made are illegal? Or all bump stocks illegal?
All bump stocks now are illegal unless you have a special permit with the new
All right,
law
now,
that they
now,
made.
explain the permit, because that to me sort of talks.
It's just a special
contradicts
permit.
itself. So if I go get a special permit, I can have a bump stock?
According to the new law.
But the guy there that bought it legally could.
Not after the new law.
I kind of want to.
I'm gonna be frank with you on guns, I'm not a big gun guy, I'm not a gun hater. They scare me for that reason right there, just because, you sit there and say 45 rounds a minute to 408 rounds a minute, that's how many more people could be killed by bullets. But at the same time too, freedom of Second Amendment is important in the United States. Why? Why is it important?
Protection.
Correct, so you can protect yourself and your family. Because if somebody comes to your house and tells you what you got to do, that's why the Second Amendment was in the, that's why it's important in the Constitution. Because if they come tell you and oppress you and hold you down, then we'll be no different than a communist country or wherever else that we're at. You got what I'm saying? So, I don't want to let these guys talk. But my thing is, whose case is this? You need to find out when the law was made and when it became illegal. And what does the law state about, are all bump stocks without permit illegal?
Can I say something? Mr. Cargill did not surrender his bump stocks under that amendment. The ATF made him surrender that, and those are not elected officials.
No,
They cannot make
no,
laws
I agree with that,
on the
but they do
Congress.
enforce the law. But at the same time, you're trying to go into the ATF. The ATF don't make laws, for sure,
Right.
because they don't have public, they don't have constituents that they have to answer to. That's why people that make laws is because they have to answer to the people. You're saying that ATF, why would the ATF, where do you get that on making a law for the ATF?
That's what Mr. Cargill told
What
me.
did he say?
He said that the ATF released a statement after the shooting and basically said that
I don't know.
bump stocks are illegal and you can't have them anymore, and then they made him surrender
Right.
them.
You said that they released that. Did they base that on anything? Because they can't make law. But I'm just saying, did they base it on law, I don't know, just throwing out a number, 2246, in the
No, sir.
code of law?
They made the amendment later on after, he didn't give his bump stocks up under that.
Any other questions, guys?
You still legally buy a bump stock as long as it's not attached to a weapon.
Yeah, you can.
So what stops somebody that has bad intent from buying that and putting a weapon? They're not going to care if they get in trouble.
Nothing.
So you can go to the store right now and buy a bunch of stuff.
You can buy a bump stock right now. It just cannot be
can't
attached
put
to
it
a
on.
gun.
So I don't think that you can legally buy a bump stock.
I can go to Dick's Sporting Goods and buy a bunch
I
of
don't
stuff.
think so. Not with the new law making it illegal. I don't think so.
Order online. You seen it? You got one?
That wouldn't be good.
No, I mean. Here's my intent on the bump stock, and this is just personal for me. Why would you want it? Why would you need
That's
it?
the point. I don't think anybody would really need a bump stock unless you're really trying to
Well-
harm somebody.
Unless there's a lot of people out there that feel like that they need to protect their place and protect their property. They would think, when we go to war, we don't go there with a single shot rifle. You understand me? We go to war with machine guns for a reason. You see what I'm saying? So I can see that. Mr. Tyler, I know you got a question.
So, having a bump stock, it benefits the gun, but you're never going to shoot 400 bullets in a round. So, not having it, because you're saving 40 per round, you're no drum magazine like 400 bullets. So,
City manager title, a direct link leads to Port Huron, official town website, and associated Port Huron email address. I would also like to bring to the court's attention a direct quote from Mr. Freed. In an ABC's News interview, Mr. Freed said, "I blocked him out of who he was, a convicted felon." The previous quote is relevant because of the Open Meetings Act passed in Michigan in 1976. This act states that all public bodies and meetings need to be open to the public. And in our new era where social media is a prominent means of communication, this act would now extend to social media, and this would make Mr. Freed's blocking Mr. Linke a violation of the Open Meetings Act. I would also like to remind the court of a precedent set in 2019 in the court case Knight Institute versus Trump. The U.S. Supreme Court of Appeals ruled in a 7-2 vote that President Trump's practice of blocking critics from his profile on his public Twitter account violated the First Amendment, similar to Mr. Freed. This was President Trump's personal account, but he used it for his official dealings as a government official.
7-2 against.
4. Against Trump. With all of these facts, I would like to implore the court to rule in favor of Mr. Linke.
Thank you. Okay, now we'll hear from Mr. Freed.
Good morning, Your Honors. Thank you for allowing us to share our case with y'all today. We are here to defend Mr. James Freed and distinguish when a public official's social media activity does constitute state action. And we can prove that Mr. Freed's Facebook page did not. He established this personal Facebook page before he was city manager. He posted things like Bible verses, his home improvement projects, and pictures of his family on this Facebook page. So when he did become city manager, Freed did post some information pertaining to the policies and activities of the city. However, in the 1988 West versus Adkins case, the court ruled that an employee of the state does act as an extension of the state when completing a task that they were assigned to do. But if no law or ordinance assigned Mr. Freed to run an account or post the information about the city, how is he acting as an extension of the state? He was never assigned to. He just did. So while he did share some job-related information on his page, it should not transform his speech into state action. And yes, Mr. Linke did comment on some city-related posts. He also commented 4 to 6 times using 3 separate Facebook accounts that he maintained on Freed's personal posts as well. For instance, Mr. Freed posted a picture of him enjoying takeout food with the mayor. Linke commented and said that they should not be indulging while the city is suffering. If this post was pertaining to the city, this argument would be completely different. But since Linke commented on Freed's personal post that had nothing to do with city regulations or new policies or updates, this has nothing to do with the city. This is just Mr. Freed enjoying takeout food with a friend. So these posts were not constituting state action since he was not mandated to run a page either, and he was not mandated to post new policies or updates. This means there is no reason as to why his personal page should be perceived as a state action. Because of this, we would like y'all, the court, to rule in favor of Mr. Freed. Thank y'all.
Any questions, guys?
How difficult is it to make a business to use your personal account, city management account, and then his family account?
See, and I think that he would have if he was supposed to. But like we said, this job description never told him that he was supposed, like he had to make an account to post these things. He just did it.
After the fact. After the fact, right? You're saying it's after the fact, what Miles said. You know what I mean by that?
Yes, sir. Like
They're arguing over something that's already happened. They could go down and divide it up and everything's okay. But he's saying that his First Amendment rights were were held back because he was doing things government on his personal account. So it's after the fact, let's say, what he asked. Does that make sense what I'm saying?
Yes, sir.
Everybody understand what I'm saying? Like now, it'll be okay, but we're arguing amendment rights off of what he said, or what he said on his personal Facebook. But I asked Ms. Fralish this the other day, what's the benefit? I don't see the benefit. What's the benefit here?
Of what?
I know he's wanting his rights have been, he thinks they're being oppressed or whatever. But what's the benefit? Why can't they just clean this up? You got what I'm saying? Why can he not separate? Was it something that has he said something to this guy? Because here's the way I look at it. Has he opened himself up to a civil issue to where that guy could sue him civilly? Like, for example, if Ms. Fralish comes up and slanders my name on Facebook on her personal account, and she says, Mr. Head says a bunch of lies about me, civilly, I could sue Ms. Fralish for slander. Is that what that they want to try to do, is to separate? You got what I'm saying? Because now he's opened up, if he's talking government business on his own Facebook, to me, he's more in violation there than for anything else.
Than blocking the guy.
If I go on my personal account on Facebook, which I don't post anything anyway, okay? But if I do, and I go and I talk about Miss Collier's second grade class, and I talk about what's going on in her class, and I talk about the school on my personal account, have I not opened myself up civilly because of confidentiality, of all those, the purpose, all the breaches of that?
Mr. Freed never said anything about Mr. Lincoln. He was just posting new updates and policies that the city had maintained.
On his personal account?
Yes, sir. And Mr. Linke started bashing him not only on
And I agree.
not only
I know
on
what you're
city
saying.
posts.
If I go on my personal account and I say Miss Collier's got 10 girls, 10 boys, 8 of them are blonde-headed and 2 of them are black-headed, I would probably get reprimanded or be in trouble through Mr. Baker for company. I'm saying the business of the city shouldn't have been on his personal account. That's just what I'm saying. To the point that when he opened that up, he sort of invited the other in. When he opened it up, they want to start talking about things of the city and putting things about the mayor. Oh, that sounds like he's gloating about, hey, I'm meeting with the mayor or whatever. And this guy is commenting on it. He took it personal then, but before that, it wasn't personal. That makes sense?
I think Mr. Herring is concerned about what's in it in this case.
Right.
Can y'all answer, either side, can you answer what's in it for Mr. Lemke? Like, if he wins the case,
Yeah,
what was his motivation? Okay, this is I'm talking, Lemke is the guy who was stopped, right?
Yes, ma'am.
Do you know, did y'all read anything about what was his motivation for pursuing a case about it? Did he just feel like his freedom of speech had been violated?
He just felt like his rights were violated. He wanted to do something about it.
Can I block anybody from Facebook? See, I'm not down like you guys, okay? All right, so can I block anyone from Facebook at any time if I have a personal post? Can I block them if I'm Mr. Baker, the superintendent? Can he? Is there a law against
I
that?
think that's what this case is going to decide.
Yeah, that's basically what this is about. Say,
His freedom of speech, he's arguing freedom of speech, and he's trying to say that since he involved government business on his personal account, he should not be able to be involved.
yes, sir.
But you said 7-2 that Trump did that on his personal and was told it was wrong because he can't. Is that correct?
Yes,
Yes,
sir.
sir.
Because he had made several posts about his, like, what he was doing as the president on his personal
Right.
account.
He's bragging for that.
Which is,
And then all of a sudden, we have some naysayers, which there's always naysayers, and he blocked.
I mean, I'm sure that y'all have seen Mr. Trump's all of his
Yeah.
social media pages. Every post that he posts is about his campaign or is about being president. There is nothing on his pages anymore that is not related to politics.
But was it because he lost 7-2?
This was before
that's where.
I think she's saying that on Mr. Trump's pages, there was no confusion about whether this is public or private. I think that's what
But it
she's,
was his personal. Correct?
yep, I don't,
He didn't, he was
7 to 2,
just posting
that's where it's
all.
gonna lie in precedence of what the 7 to 2 was. 7 to 2, it was stated, was it a lower court?
what was it? Yeah,
U.S. Supreme Court of Appeals.
yes, it's a lower court.
Lower court? So the lower court already set precedence of that he can't block votes or from his account where he's talking about precedent. We've already got precedence there if that's legit. But if it's not legit, I don't.
Kaden, did you have a question? You do? She's got a question.
This is, people can block anybody at any time. I could block anybody. But the thing is, like y'all said, I would understand if it would have been about a city-related issue. But just because he was having lunch with the mayor, what does that have to do with the city as a whole? What does that have to do with the community?
He had made posts about like how the city was dealing with COVID on his Facebook account.
Another question, did he just block him from the thread, or did he completely just block him altogether?
Well, he commented, like I said, he commented 4 to 6 times on 3 different Facebook pages that he maintained on multiple posts,
Would the
not
thread
just
mean-
city related.
Not the issue that you're talking about?
Yeah, just that one
Just that
post.
particular.
But no, he was commenting on everything 4 to 6 times in 3 different
He
profiles.
was harassing.
Yeah.
Yes, sir. It was not a civil manner, just commenting, hey, Mr. Herring, I do not like that you are announcing Ms. Collier has 2 dark-headed
Right.
kids in her class.
Just everything he put on there, he was.
Yes, it didn't matter what it was. Every post
Bunch of people, little
was a
kids
call.
back there. No, no.
He actually has been arrested for cyberbullying in the past. Smiling at his picture. Yes. And I would also like to talk about, they mentioned that he was kicked out of a meeting where the public is supposed to give feedback. The reason he was kicked out of that meeting was because they give the public time to give feedback and give their response, and the public time was over. Now it was strictly just the officials talking and doing their dealings, and he was still trying to be obnoxious.
You say he was a felon? What about that? What kind of felon? That would matter too, in a public building or whatever. Like if you was a sex offender, you have to report, you can't be within a certain amount of, square footage of a school or public building, things like that, and y'all know what it is.
Yes, sir. He had a felony for assault, and then he also had another felony for assault and battery.
And assault, battery, and assault, and then cyberbullying?
Yes, sir. I'm sure Mr. Freed was a little scared whenever he was harassing him on Facebook, and he has a past of being violent.
Did you have a question?
The information he was going to see was it posted anywhere else where he could have seen it?
I do not know that information.
Which there again, all the stuff about the person and all that is really not pertain to what the ruling of the law is. You have to sort of take all that out, all that personal stuff, and figure out whether it's against the First Amendment or not.
Yes, so the reason that we were bringing that up is because the constitutional question, like the whole thing about this case
It
is.
doesn't say that I have freedom of speech unless it's a felon.
Yes, sir. The question is, was Mr. Freed acting as state action, or was it personal? Because if it was state action, he did have a right to get feedback. But in this case, it was not. I don't know if it was a specific comment because there was so many 24/7. Yes, sir.
Which means a public official, it's above his office.
All right, our next case is McElrath versus Georgia, and we'll be hearing from Mr. McElrath's side first.
Good morning, Your Honors. I hope your day has been well so far. I'm here today on behalf of Mr. McElrath, but I'm also here today on behalf of the Constitution of the United States, especially the Fifth Amendment. So, if you're here today and you're asking yourself, does the double jeopardy clause of the Fifth Amendment prohibit a second prosecution for a crime of which a defendant was previously acquitted, then your answer today is yes. The Fifth Amendment clearly states, no one shall be tried twice of the same offense to be put in jeopardy of life or limb. As a result, we argue that no judge can overturn an acquittal, even if the acquittal is based on bias or mistake. And it was stated that he was acquitted on malice murder for grounds that he has a mental illness called schizophrenia. Therefore, it is not my client's fault that a Georgia jury made a mistake in the ruling. I have also noticed that the trial court accepted the verdicts. Now, the Georgia Supreme Court says that the verdicts are repugnant, so they vacated the verdicts, remanding my client's case for retrial. This goes against everything the Fifth Amendment stands for. Now, had the trial court not accepted the verdicts, this case may be different, but they did. Therefore, this case shouldn't even be an argument. Now, I also know we are here today because the Supreme Court does believe the verdicts are repugnant and that this is ground for retrial. But we cannot forget about the Supremacy Clause in Article 6 of the Constitution. This article points out that anything in the Constitution or laws of any state to the contrary notwithstanding, which is basically saying that the Constitution overrides any state law, even Georgia's. With that being said, I think we all need to remember what this nation was founded on, the Constitution. So, if you choose to have a retrial, you are not only going against the Constitution, but also against the justice this country has fought so hard for. It only takes one person to bend the rules of the Constitution to start a downward slope of this country. So, I want to leave you with these questions today. Without the Constitution, what would this country be? But more importantly, what would this country be without people such as yourselves to enforce the Constitution? Now, I would like for you to remember those questions as you make the decision whether or not to send a man who has already been tried and given verdicts that have been accepted back to trial. And please remember his constitutional rights. Thank you for your time today, Your Honor.
And now we'll hear from the side of Georgia.
Good morning, Justices. We represent the state of Georgia, and we also stand as advocates for justice and are here to clarify the constitutional question plaguing this case. Would Mr. McElrath's constitutional rights under the Fifth Amendment be violated and he be subject to double jeopardy if he were to be retried for the crimes against his mother? I now pass it over to my partner, Attorney Sanders, to discuss the background of Mr. McElrath's case and the ruling over lower courts and the Supreme Court of Georgia.
The verdicts of Mr. McElrath's previous trial are as follows. On the count of malice murder, he was found guilty or not guilty by reason of insanity. And on the count of felony murder, he was found guilty of mentally ill. That's two verdicts that are against each other that contradict each other. So how can a man be capable of at the same time being ill, mentally ill, but insane, and sane at the same time? So, such that ruling prompts the lower court to do the Georgia's repugnant rule, which clearly states a jury cannot find a man guilty and innocent at the exact same time, with respect to the same crime, both of which Mr. McElrath was found to be first ruled. So he was found to be guilty but insane, but not guilty but insane. So that rule states that if a jury were to rule two rulings that contradict each other, then that ruling should be vacated and there should be a retrial. And now I'll pass it back to the Attorney General.
Under this ruling, the lower courts found Mr. McElrath's charges to be acquitted, which means that Mr. McElrath's charges cannot essentially be held against him as they are too contradicting. Now, a vacated verdict, understanding what a vacated verdict means, that the verdict is now, or charge is now null and void. When this case was presented to Georgia Supreme Court, the verdict of acquittal was found to be vacated. So the current acquittal was now null and void when taken to the U.S. Supreme Court. With such ruling in place, it is only logical that Mr. McElrath be retried and receive an explicit and clear ruling without any confusion, which is why, without a clear verdict, Georgia Supreme Court ruled that both of Mr. McElrath's charges be vacated. Today, Mr. McElrath appeals to this court, arguing that our Constitution's Fifth Amendment, under our Constitution's Fifth Amendment, he shall not be subject to double jeopardy, no matter what state law has previously ruled. Constitutional laws are protected under Article 6, Paragraph 2 of the Constitution, stating that federal laws take precedence over state laws. And as a citizen of the United States of America, this is Mr. McElrath's right. If he were to be acquitted on any charges relating to any crime, then a jury's verdict of acquittal terminates jeopardy. Yet, the Supreme Court turned over the acquittal, vacating it null and void. Mr. McElrath's charges merely allowing for legal retrial of this case without coming into any violation of McElrath's constitutional rights. So when deliberating over this case, we strongly urge you to understand the facts of our arguments, because only there will justice be found. Thank you.
Do you understand what they said?
Two charges in Georgia. You can only have two charges in Georgia. They're either guilty, or what did you tell me it was?
Malice murder.
Malice murder and felony murder.
Mm-hmm.
And they charged him one with insanity, the reason of insanity.
But then guilty
but
of
then
it.
not guilty on the
Right.
And they're saying that there's two charges. You can't have two charges. The state saying you can't have two charges.
Well, the state is saying that it's okay to retry him because what they did was throw the whole thing out. They vacated it. There's been no decision. But Mr. McElrath's side is saying, yes, there was a decision. They acquitted me because there was a contradictory verdict. They acquitted me. So there has been a decision, so you can't try me again. So there it is.
Did the Georgia Supreme Court has already overturned this? So where he can be tried?
Well, it's an undecided decision. The Supreme Court is still reviewing the case.
The Georgia Supreme Court?
And that's the question. And see, that's the other side's question. Can Georgia do that?
That's what I'm asking. That would be my question.
Well, that's what the Supreme Court is going to decide in this case. Yeah. Can a state do this?
Take away the
Protection
Double
against,
jeopardy.
does this come under that? Under that double jeopardy? Georgia's,
Who's pushed out? I mean,
what now?
the state pushing this? I know the state's pushing it, but who's pushing the state?
McElrath has brought, McElrath is
No.
bringing the case.
How did it come back up? Was there a lot of time in between when?
No, sir. So originally, Mr. McElrath did not want to pursue an appeal because of the original
He got
trial
off,
verdict
correct?
benefited him.
Yeah,
as-
he got off.
He got off of it. But then he realized that his time would be spent in a mental institution. So now he wants to retry and say that he cannot be retried. His charges were acquitted, so therefore he should not be institutionalized.
So, okay, all right, okay. So he's gonna be put in mental institution
That's what I read.
on the one verdict.
Yes,
One
sir.
verdict he got off of insanity. That's the reason he's going. One verdict they found him not guilty.
Yes, sir.
And so he's going out completely.
Yes, sir.
So he's wanting to, I thought he was the one that didn't want to be tried. Am I wrong?
He originally did not, but now when he realizes he is being institutionalized, he wants a retrial.
We're here today because they're trying to throw out his old trial of which he was already acquitted.
Right.
When you're already acquitted, the double jeopardy of the Fifth Amendment, it says you cannot be tried again. Now, had they not accepted the verdicts, then it would be different. But they did accept him, and now they're wanting to try him again, and they can't do that. So he's not wanting a retrial because he's going to a mental institution. He's here because he doesn't want to be tried again at all.
That's, okay.
But Mr. McGowan was the one to appeal to the
That's what I'm
Georgia Supreme Court.
asking. If he appealed, what's he appealing? What's he
Because
appealing?
they're saying that his verdicts are repugnant, and they're trying to send him to prison or a mental
So he's
institution.
just to get sent to the mental institution, so he don't want to go to either one. So the reason he's appealing is he's trying to get out of the mental institution. He's already got out of the prison sentence. And so now that he's appealing it, the state said we just want to retry the whole thing.
Yes.
Correct?
He's saying, since my case was decided already, you can't now up and just vacate it.
But he's also appealing because he don't want to be placed in a mental institution.
Does it matter
On the
why
first
they're,
verdict.
does it matter their intent? We have, the court has to decide if, it doesn't matter their intent or their background or who they were or
Doesn't matter
what kind of
intent.
felon they were. Has the law been violated?
But isn't it contradicting what he's saying? That he's asking for but then don't try me again? He's appealed.
Did he
He's appealed the verdict. That's what they said, so he don't have to spend time in
He
jail.
appealed because he wanted to appeal only the felony murder charge,
Yeah.
not the
Picking and
malice
choosing.
murder charge, which he could be sentenced to death for. And he was insane, and
But at the end of the day, he don't want either one. Correct? Or he wouldn't appeal. Am I right?
He's going to the mental institution.
That's why he's
if
appealing.
he's appealing because he doesn't want to go to prison. He is insane. He's
Right,
appealing
right.
because he doesn't want to go to prison because he's only appealing the felony.
But I thought the first verdict was that he was not guilty on the one of malice, murder.
yes, sir.
Yes, he's not guilty because of reason of insanity, so he would be going to a mental
Mental
institution.
institution. That's why they're appealing, because he don't want to go in.
No, he's appealing the felony murder because he was acquitted of malice murder. He was not acquitted of felony murder.
See, if he gets
was acquitted of
retried, he could be found guilty of malice
I know.
murder.
I know.
And that's where he's,
But I'm just saying, I thought that me appealing was going to cause me to go get the death penalty. Josh wouldn't be appealing. You see what I'm saying? So to me, he's trying to pick and choose to get out of both of them.
I don't think he's trying to get out of malice murder because he's not trying to appeal malice.
If he was acquitted.
He's not appealing malice murder. He's appealing felony murder. So he's only being tried for felony murder because they didn't say
Make a
he
ruling.
was acquitted.
They didn't rule.
But the case is whether or not it's double jeopardy.
is being retried. The question is being retried after somebody says, okay, we're just gonna vacate all of it.
I can see that according to the
Is
Constitution.
that
I can
double
see
check?
that. I can see that. And if they accepted it, I can see all of that. I'm getting confused on are we trying to just get out of everything? Are we appealing, you said he was acquitted on one set of murder, but the other murder he was not acquitted for reasons of insanity. The reason of insanity is going to put him in a mental institution. Why would he appeal the verdict where he was acquitted?
He's not appealing the verdict where he was acquitted. He was appealing the verdict where he was
Reason of
not
insanity.
acquitted. He was
Of insanity.
acquitted of reason of insanity. He was not acquitted of reason of not like mental illness or felony murder. So he's going to say, I'm appealing felony murder because I don't want to go to prison. He is going to the mental institution either way.
I would just like to make it known to the court that the repugnant ruling, which is our main defense and our argument, is not a law in Georgia. It's a rare circumstance of ruling that may be used.
Now, repugnant means
It's repugnant means that when two verdicts contradict one another, in our case, insane and sane at the same time with respect to the same crime, that the ruling shall be vacated. But the repugnant ruling is not a law. So
that's what you were saying on the contradicting.
Therefore, this ruling does not violate Article 6 of Paragraph 2 of the Constitution saying the Supremacy Clause, because it is yet a law, and the Supremacy Clause clearly states that federal law precedes state law, not rulings.
From the Constitution.
From the Constitution.
But the repugnant rule is not in the Constitution, but the Supremacy Clause is, and so is the Fifth Amendment.
It is, but...
And the Constitution overrides everything, not just state law, but any rule that may be used.
But the Constitution clearly states that federal law precedes state law. That is the Supremacy Clause as written.
Hey, Your Honors, do you think you have enough information to be able to? Do any of you have any other questions?
Whose case is this?
Whose case? What now?
Whose case is this?
Did any of you have this one? See, there's one case that we didn't have enough of them to be the background on. But if you'll have some questions, I'll make sure that we find the answers.
My question would be what they said. I know the Constitution. I know the situations on those clauses and all that. I understand that. My question is what the guy his appellate. What's the appeal?
What? Okay.
What was the original verdict, and what's his appeal? That's what I want. And you're stating that y'all are contradicting the Fifth Amendment somewhat.
Yes.
It's what you're saying is not what she said, and I know that's an argument. You know what I'm saying? But what you're saying is different than her. Why? Why is it different? You're both are quoting the Fifth Amendment. You're saying one that is not the Fifth Amendment.
Because Avery's saying it doesn't, what's happened hasn't violated the Fifth Amendment.
One said Supremacy Clause and one said...
And Reese is saying what has happened does violate the Fifth Amendment.
What we're saying, Reese is saying that the previous lower court ruling violates the Fifth Amendment, double jeopardy, because of a previous acquittal that was soon overturned by the Supreme Court of Georgia and vacated, so rendered null and void. Yeah. And then we are saying that the repugnant rule, which vacated the acquittal, is not a law, so therefore it's not following the Supremacy Clause.
Okay.
If it's not a law, then why would we use it anyway?
Because this is the first time it's ever happened, and many people have said that it would be the last time it would probably take place.
It is the first time.
Okay, let's stop.
We better move on.
That's right. Okay, next case is another Second Amendment. The next case is another Second Amendment case. And this is the U.S. versus Rahimi. And we're going to hear from U.S. first.
Good morning, Your Honor, and thank you for hearing my case today.
In the winter of 2019, Rahimi and his girlfriend were arguing in a parking lot because he was threatening to take their child away. When she tried to leave, he grabbed her, pushed her down onto the ground, and then he shoved her into his car, which made her hit her head. Rahimi then realized that a bystander had witnessed his abuse towards her. He then grabbed a gun out of his car and opened fire. During this, his girlfriend ran away. He later called her that night and threatened that if she told anyone that he was abusing her, that he would shoot her. In January of 2020, the court granted Rahimi's girlfriend with a restraining order against him. The judge that granted the restraining order to the girlfriend found that he had committed family violence. When under a restraining order, you are not allowed to have any contact with the person that orders it. You cannot text on anything, even social media, and you cannot go near the home. Rahimi denied the order and reached out to his former girlfriend on social media and went to her home in the middle of the night. The state also warned Rahimi that possessing a gun while he was under the restraining order is a federal felony. Rahimi kept his guns. He used one of those guns to threaten another woman. Months later, in the winter of 2020, Rahimi was involved in 5 shootings in the span of several weeks. Rahimi fired an AR-15 into a man's home after he trash-talked him online, after buying drugs from him. The next day, during a traffic crash, he shot at a driver. He also had been accused of shooting into the air of a residential neighborhood 3 days after that. A few weeks later, after a truck flashed his headlights at him, he followed his truck and shot at another car. In January, he fired shots into the air after his friend's car got caught at Whataburger. Rahimi also shot at the constable's car, which is law enforcement, which in turn means Mr. Rahimi is violent towards law enforcement. Authorities found connections with Rahimi with the shootings. The authorities got a search warrant and found a .45 caliber pistol and a .308 caliber rifle, pistol, rifle magazines, ammunition, and a copy of the restraining order. Rahimi was then convicted and then challenged the order of law, saying that it violates his Second Amendment rights and his right to bear arms. The Second Amendment states that people have the right to bear arms, but it also protects an individual right to possess a firearm for traditionally lawful purposes, such as self-defense within the home. Mr. Rahimi has used his Second Amendment rights for beyond self-defense and lawful purposes. He has done quite the opposite. He has endangered multiple people's lives under this. While having a restraining order on you for domestic violence, there are multiple laws that you have to follow. The firearms prohibition for domestic violence protective orders in Texas states, Texas law prohibits people from possessing firearms while they are subject to domestic violence-related protective orders, issued in Texas once they have received notice. The law Rahimi states is unconstitutional, states that it criminalizes an individual's rights to ship, transport, possess, and receive firearms or ammunition when the person is subject to a domestic relations restraining order. Rahimi believes his Second Amendment rights are being infringed because of this law. Although he endangered a witness to his abuse on his girlfriend, as well as threatened 2 women's lives by threatening to shoot them. Rahimi is challenging that a federal law that has been in place for 30 years that strips guns ownership rights from people under domestic violence protection orders, which has been very effective, is unconstitutional. This law has helped save lives by stopping over 77,000 purchases of weapons by individuals who are subject to domestic violence orders. This law is not unconstitutional. It is protecting the laws of women subject to violent men. It is also protecting the lives that Rahimi has endangered and threatened, and it also protects the potential victims of his abuse. Thank you for hearing my case here.
And now we'll hear from Rahimi's side.
Good morning, Your Honors, and thank you for hearing our side this morning. I would like to start off by reminding the court that this case is not on individual crimes that Rahimi has committed and if he is guilty or innocent or not of those. It is specifically on the indictment being on the restraining order taking his gun away. Now, we believe that the court should affirm the decision of the lower Fifth Circuit that 18 U.S. Code 922, Section G8 is unconstitutional because of the Supreme Court's decision in Bruin's case, which ruled that the gun restrictions are constitutional only if there is a tradition of such regulation in U.S. history. First, this law that is taking his gun away is a total ban on possession of any type of firearm or ammunition, even in the home. Second, the ban is enforced with several criminal penalties of up to 10 or 15 years in federal prison. Third, the ban applies to United States citizens who retain all their political and civil rights. Fourth, the ban is not triggered by conviction of infamous crimes. It arises automatically and unavoidably from a civil state court order, often after a one-sided proceeding, regardless of whether the order itself addresses firearms. So this could mean that you don't even have to do anything for this law to take your gun away. Someone could reasonably, or just say that they're scared that you're going to hurt them or their child, and you can get your gun taken away from that. Does this law violate the Second Amendment on its face? Well, here is the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. If this law is deemed constitutional, it will be a slippery slope. Is a restraining order enough to deprive one of their right to obtain a firearm? A right absolutely guaranteed to someone not just for personal safety, but also to us as a whole people as protection against a tyrannical government. Keep in mind the importance of upholding the right to bear arms, and imagine the slippery slope of letting something so broad as a restraining order take away that right. This could be on the same level of getting in a fist fight and getting your gun taken away. Where is the line drawn? Here is how easy it is to obtain a domestic violence restraining order. In other words, how easy it is to lose your right to bear a gun.
Under Section 18 of 922, the right to possess firearms can be taken away if a person has a domestic restraining order filed against them. However, this domestic restraining order can be granted for anything that can be construed as conduct that would place an intimate partner in reasonable fear of bodily injury. Not only does this tell an individual that prioritizing restraining orders over the protection of our constitutional right to possess firearms is more important, but any restraining order could very well be falsified. Family law attorney Nicole K. Levy states that restraining orders can be falsely obtained through exaggerated or false claims of abuse. Few would question that restraining orders are crucially important to the protection of victims of domestic abuse. However, the very nature of domestic abuse, which occurs behind closed doors, away from eyewitnesses, sometimes invites false, exaggerated claims of abuse that lead to the entry of unfair or unwarranted restraining orders. Should those with protective orders against them be held to the same standard as felons under such a broad law that can be misconstrued? Criminal enforcement of this overbroad gun law fuels mass incarceration and the disproportionate imprisonment of people for seemingly unrelated circumstances. Such gun laws can raise due process, equal protection, and excessive punishment concerns, none of which is addressed by this case. If taking away the right to bear arms under circumstances that are very difficult to prove, such as a restraining order, is allowed, the implications of such a ruling could let the gun rights of others be infringed. I'll now let my partner talk on related cases.
A related case that we have is Matt versus Ohio. This went to the Supreme Court. It was about evidence found illegally. If the evidence is found illegally, it cannot be used in a court of law because it violates the right to privacy. Yes, that has nothing to do with the Second Amendment, but the principle behind this ruling does. Justice Tom C. Clark was aware that the court's ruling would sometimes result in criminals going free because of an error on the part of the police. In this possibility, he responded, "The criminal goes free if he must, but it is the law that sets him free. Nothing can destroy the government more quickly than its failure to preserve its own laws, or worse, its disregard of the charter of its own existence. Now this may seem scary, but let me explain how it's related to this. Oh. If a criminal goes free, it is the law that sets him free. Being this man cannot be indicted on such a broad law. We're not going to pretend that this man is a good man. I'm here on the side of the Constitution. But if this law is constitutional, it's going to violate the rights of so many people. They can take him back to a lower court, for all we care, and indict him on something else. But this specific law, they cannot. Taking away the right to bear arms over any little infringement completely disregards the reason to our own government's existence. We were built on a social contract by the people, for the people, who had just declared independence from a tyrannical government, who understood the importance of protecting our delicate rights.
A counter-argument can be raised which states that the Second Amendment only pertains to organizing militia. In 2008, Anthony Scalia ruled in District of Columbia versus Heller that the Supreme Court majority opinion stated the Second Amendment protects an individual right to possess a firearm unconnected with the service of militia and to use that arm for traditionally lawful purposes such as self-defense within the home or for recreational purposes. Another is McDonald versus the City of Chicago in 2010, where the ruling also affirmed this. Those are past cases. Recently, another case has been raised called New York State Rifle and Pistol Association versus Brewing. This is the case that got the lower court ruling overturned and is why this case is getting appealed. This states that gun restrictions are constitutional only if there is a tradition of such regulation in U.S. history. This law, 922, does not. Before June 23rd, 2022, courts agreed that it was perfectly constitutional under the Second Amendment to disarm people who were subject to domestic violence restraining order like Mr. Rahimi. The Fifth Court Circuit, too, had upheld the law at issue in a case called United States versus McGinnis, but on June 23rd, 2022, in New York State Rifle and Pistol Association versus Brewing, the Supreme Court cast doubt on virtually all past Second Amendment decisions, including McGinnis. If the U.S. Supreme Court isn't attempting to appeal the cases of Brewin or Heller, then it would be completely contradictory to rule against the protection of Mr. Rahimi's gun rights in this case. The founding generation feared a presence of an all-powerful federal government. They would have resisted a federal law that cherry-picked, with very little reason, which citizens could, and when citizens could not, keep firearms, a right so clearly outlined in our own Bill of Rights.
We are here because the U.S. upheld on the ruling that we were in the right, because the Supreme Court ruled in Bruin that historically speaking, if there's been no history of regulations like these, then they're unconstitutional. Our founders were even so determined to protect our right to bear arms that after Shays' Rebellion, they required that officials return their arms. The approach that the government is taking towards gun restrictions would not work for any other constitutional right. The protections of the Second Amendment must be guarded with the same vigor as other constitutional rights. The power to ban obscenity and libel does not imply a power to decide who may speak in the first place. The power to ban riot and unlawful assembly does not imply a power over who may assemble in the first place. I will conclude now. It is absolutely necessary that the court rule that 922 Section G8 is unconstitutional. If this law is allowed to be deemed constitutional, a dangerous door could be opened, slowly moving towards a tyrannical government. People could lose their right to bear arms over almost anything. Our government was built on consent of the governed. As soon as the right to bear arms is infringed upon, the right to consent to your government is thrown away. There is no way to stand up to your government. Guns are the people's checks and balances. This is why this is so important to be specific in the way that we restrict guns. Some might argue that allowing this law to stand would provide the people more safety in all regards and against gun violence. But consider this quote by Benjamin Franklin. They that can give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. Thank you.
Whose case is this?
Whose case is this one?
We're not interested in protecting the rights of Mr. Ariton. We're interested in protecting the rights of those that can be falsely accused of domestic violence under such broad terms outlined in 922.
There are ways to protect domestic violence victims without taking guns away from everyone, even if people are just scared that they might hurt them. Because this law is so broad. If, yes, Rahimi has committed certain acts, but legally, if we're going to indict him under this law, it's going to open a door to some really dangerous stuff. So if we want to indict him, sure, take him back to the lower court and get him on something specific. That would be fine. But it is unconstitutional to do it on such broad terms.
It's a long-standing tradition, and in the case recently that I spoke of involving Mr. Bruin, the traditional process of determining whether or not Second Amendment constitutional cases brought to the Supreme Court, how their process got completely overchanged. That was in 2022, and it has been referenced by judges as casting doubt on all virtual past Second Amendment decisions. And I think that this 30-year tradition of disarming people's past gun rights are overturned because of historical context.
You keep saying 30 years. Tell me about that. Why 30 years? Is that when the law was enforced?
Yes.
Read me the domestic violence law. That's in place correct now?
Yes.
What does that say? And then did he have any other charges? You're telling me he went through all that, shooting in the parking lot, shooting the car, shooting at Whataburger, shooting everybody up, and they ain't charged with anything else?
No, sir. He has no current
Zero
felony
charges.
charges. Zero.
Sounds about right.
There's nothing. He hasn't been charged.
I don't know, they ain't charged with
in
that?
jail for the next 6 years for those charges.
What's
He's
that now?
made bail and is on hold because of this.
So he has been charged.
Yes, he was charged with all 5 shootings in suspicion of that.
So,
But not convicted yet, is that right?
He's not convicted for shooting at his girlfriend.
all right, so he was arrested, and he's been charged, and he's not convicted. And you're saying that the government are trying to strip his guns from the Domestic Violence Act.
Right.
Is the Domestic Violence Act tied to any of those charges if he was convicted?
No, but he was.
Do you understand what I'm asking?
Yes,
In the
sir.
Domestic Violence Act, does it state in there if you're convicted of this crime here, does that relate to the Domestic Violence Act?
Basically, all that the law states, this law is a very complicated law that is mostly dealing with across-state commerce, transportation of guns. But the only section is one teeny tiny little section that prohibits people with a protected order to have their guns taken away from them for anything that falls under conduct that will place an intimate partner in reasonable fear of bodily injury. That is a direct quote from the law.
And may I remind the court that even if he had been convicted of these crimes,
They're only charging with that, what you're saying.
right, exactly, because he hasn't been convicted yet, so it's only on that restraining order.
They're only doing the restraining order.
Exactly.
I was just asking that from my knowledge. I know what you're saying. But you can't use any of that because they're not bringing that to the court. I understand that. But I was just wondering, if he did all that, he should have already been locked up. But at the same time,
That is what we were going to bring up had we not been so long-winded already.
yeah.
but he is not a current felon. He has not been convicted of any crimes as of now, and we are not on trial for those crimes. We're on trial for whether or not this amendment. or
You're just
this
talking about
law-
section 922.
Yes, sir.
And in this law, you don't even have to have done anything for the law to take your gun away. Somebody can just say that they're scared, that you're going to hurt them, or
Have they
they're
done
trying
that before?
Have they done it before?
Have they taken guns from people before for that?
Yes, sir. It is that I have actually a direct quote from a family law attorney, which is what Mr. Rahimi was accused of in court. And it is a widely known or held opinion that restraining orders can be falsely obtained.
But the Bruin case wasn't even about domestic violence or abuse or anything like that. It was about having a gun in public for self-defense. Bruin was saying that he needed a gun in public for self-defense, but he was never using his gun for self-defense. He was using it to endanger other people's lives.
We're not trying to use Bruin to affirm that this.
Is that proven?
Sir?
I'm just saying, was that proven? Was that just
That was proven.
not what she said? Is that proven?
Oh, yes, sir. That is what that case pertained to. But we're not looking at Bruin for
You're not going into
domestic
that he's a good
violence.
guy.
We're looking at this of how to process this with the Supreme Court.
You're not going that he's a good guy. You're.
No, sir.
you're just talking about this.
Right, how to process gun restraints. The reason that the lower court ruled in favor of us was because the Supreme Court ruled in favor of Bruin, and then the Fifth Circuit, deemed this law unconstitutional because of that ruling.
We first received, we appealed after he got arrested in family court, and then we were dismissed. And then once that case was ruled by the Supreme Court, the Fifth Circuit Court of Appeals then came back to us.
We good? You have a question?
All right. Gosh, first of all, I hope everybody still likes everybody after this.
Yeah, that's a good argument.
It's Christmas season, you know, you gotta forgive.
One thing you have to do is, like you said, there's a lot of personal involvement in what you did. You all did very good. I did good. But there's a lot of personal involvement in what you did and what you studied. But you also do have to, what Mr. Fralish said, I think a while ago, to eliminate all the personal things and just look at, you gotta look at the law.
And the thing is, and the reason I like for y'all to do this, is because our Supreme Court is constantly ruling on decisions that affect our daily lives. And it's hard. It's hard for them to weed through all of this stuff and come up with, okay, what supports the essence of being an American. You know?
The Constitution.
Yep.
It's what's supposed to go
That's what they're trying to, that's what they're supposed to uphold, is the
A lot of people
Constitution.
that go back and say that the Constitution is out of date, they want to say that.
Well, the Supreme Court is keeping it up to date.